This is the Northern Ireland Assembly Committee Room 21. This is the Northern Ireland Assembly Committee Room 21.
You're all very welcome to the committee recess. If you can do the needful with any electronic devices, that would be helpful. There'll be an oral evidence session that Hansard will cover during the meeting as well. Just to advise members, Keith McBride has joined the committee as a senior assistant clerk, and on behalf of the committee I'll welcome him to that new role and wish him well. Marie Austin has moved on to the Health Committee. So if I could just place on record my appreciation for the work that Marie carried out. I know she'll be a great loss to the committee and was always very helpful to members and assisted us greatly, particularly on the human trafficking bill, to try and help members get through that. So if members are agreeable, we'll send a letter to her thanking her for the work that she carried out on the committee. And wish her well in health. Yep. There's no apologies apart from Mr. William Humphrey. The Decal Committee is in Enniskillen today, so he's been unable to attend the committee meeting today. There are draft minutes of the meeting that was held on the 2nd of July, and if members are content that they're accurate, I'll sign them accordingly unless there's any changes members have. Okay, agreed. Some matters arising. There's a forward work programme for September that's been provided in your meeting folder. An informal strategic planning meeting is scheduled to take place next Wednesday prior to our committee meeting, and this will provide an opportunity for members to discuss the priorities and the work programme in more detail. So if members are content, we'll note that. Item 2 is correspondence from the Department in respect of the RUC George Cross Widows Association. A response has been received from the Minister in relation to the funding, which was brought to the Committee's attention in June. That has now been resolved to the Association's satisfaction, and it will receive its grant of £25,000. There's also a letter from the Widows Association expressing its thanks to the Committee for our intervention in this important issue to them. So a copy of those letters are in your meeting folder. Other items, Justice Bill Clause 84, there was a response received from the Department in response to the issues that have been raised in relation to Clause 84 of the Justice Bill during an oral briefing on the principles of the bill back in June. The relevant papers are in the meeting folder. The Department has stated that it's confident Clause 84 will deliver both the spirit and the letter of what was recommended in the Youth Justice Review, and that it will therefore be compliant with the terms of the United Nations Committee on the Rights of the Child, and that's in respect of the revised aims of the youth justice system, and a response will be included in the bill papers for future consideration on that particular issue. Okay, the next item then is the Human Trafficking and Exploitation Bill.
Chair, just for clarification, what time is the planning meeting next Wednesday?
At 12:45.
Sorry.
It'll probably be upstairs in the private members' dining room.
45.
This item then is the draft amendments following the Department of Justice consultation on strengthening the Northern Ireland's response to the Human Trafficking and Slavery Bill. Obviously we have officials here today in terms of updating us around the work that's been carried out in conjunction with Lord Morrow in relation to his bill since the completion of the committee stage, and to outline then a range of amendments following the Department's consultation are there for members as well. There's a paper that was circulated this morning, and that is on pages 3 to 29 of your tabled pack, which sets out the new position and the proposed amendments, and the committee position as outlined in the bill report that was published in April to assist consideration of the bill. The Department has also provided an update on the Minister's engagement with the Home Secretary on extending the role of the Anti-Slavery Commissioner to cover Northern Ireland, and on maritime powers, both of which require a legislative consent motion, and the relevant papers are also in the tabled pack. So let me welcome Simon Rogers, Deputy Director from Protection and Organised Crime Unit, Julie Wilson, Head of Human Trafficking Team, and Amanda Patterson, Head of Criminal Policy Branch. You're all very welcome at the committee meeting as always. This session will be recorded by Hansard. Just to advise members to try and get a bit of structure to this session, I'll invite officials to provide a brief update on the work that has been taking place regarding the bill, and then I intend to go through the clause by clause basis. So,
is that on the basis of this memorandum?
yes, we will refer to that table of information and go through each clause. So, if members have a question on clause 1, then we'll deal with it in that order to try and have some structure. So, Simon, I will hand over to you at this point, and then we'll get into clause by clause consideration.
Thank you, Chair. The Department is grateful for the opportunity to brief the committee on the proposed amendments to the Human Trafficking Etc. Bill that the Minister and Lord Morrow intend to table in effect jointly. They believe that these will add markedly to the value of the bill. We'll also take the opportunity, as you've mentioned, to update you on the Anti-Slavery Commissioner. The committee is aware that the Minister and Lord Morrow have been working closely, and aside from clauses 4 and 6, they've reached agreement on nearly all the provisions in the bill that are before the committee. On clause 12A, which we'll go through later, we're still discussing the detail. Our written paper provides the proposed amendments as well as setting out in detail how they would impact on the structure and substance of the bill. And I just want to draw out a couple of overview points for the committee's attention. During committee stage of the bill, we provided the committee with a number of draft amendments agreed jointly by the Minister and Lord Morrow, and indicated that further amendments were likely to follow on a number of areas that had still to be resolved. We also noted at the time the Department's consultation on the new measures relating to human trafficking and slavery through our consultation document, which we'd reported on. Since then, we've been working with Lord Morrow and Legislative Council on amendments. These would introduce the additional provisions set out in the consultation and would significantly alter the structure of the bill. Lord Morrow has helpfully agreed to these additional measures. He and the Minister agree that they provide a more robust, effective piece of legislation while retaining the bill's fundamental purpose and intent. Just one thing to highlight at this stage is that given the comprehensive nature of the additional proposed amendments, there's quite a lot of changes to the structure of the bill, which we'll work through. But Legislative Council in particular has suggested that if accepted, the amendments would mean that the existing title of the bill would need to be adjusted. And Lord Morrow and the Minister support that proposal, and you'll see the new title of Human Trafficking and Exploitation, brackets Criminal Justice and Support for Victims, brackets Bill. The other issue, briefly, that you mentioned was about the continuing engagement between the Minister and the Home Secretary on the Anti-Slavery Commissioner, which is a provision included in Westminster's Modern Slavery Bill. Since we wrote to the committee, there have been developments on that, in that the Home Secretary has written to the Minister and to his Scottish counterpart, offering to add a number of provisions to the bill in respect of the extension of the Commissioner's role. And we've sent details of these through, and I think that's probably the letter, Chair, that you referred to. And we can come back to the detail of that if you wish later. The Minister believes that the additional measures which the Home Secretary has put forward would provide appropriate cover for Northern Ireland interests, and as such would intend to seek the Assembly's consent to Westminster legislation to achieve the changes. If the Assembly consents to this, we understand that Lord Morrow would then agree to remove clause 16, which relates to the Northern Ireland rapporteur from the bill. In addition, as you've mentioned, the Home Secretary and Minister have been exchanging on issues concerning criminals who are involved in human trafficking and slavery and who operate at sea. At the minute, there's a gap in the provisions in that area, and we're proposing to try and fill that. And having consulted the Chief Constable, Policing Board and Police Ombudsman, the Minister intends to seek the consent of the Assembly to introduce appropriate provision covering Northern Ireland waters within the Modern Slavery Bill as well. Obviously, we'll provide the committee with further briefing on the proposed legislative consent memorandum in due course. So just to conclude, in summary, we believe we've made very good progress on the provisions in the bill with Lord Morrow. The Minister is grateful in particular, and I'd like to record the cooperation and partnership with Lord Morrow and his team in shaping and agreeing the proposals, and obviously we're happy to go through those in detail now. Assists.
Okay, well, that's helpful. So we'll start going through the clause by clause. Just for members' benefit, obviously we concluded all of our report on this and took positions on the various clauses. I think it would be helpful next week, once we've teased out some of the issues, that next week we can go through and go, this was clause 1, the committee was happy with it, are we happy with clauses, the revised clauses? So I would intend next week to try and go through that, just so that we can update the Assembly when it gets to the consideration stage. The committee position. The committee position was clause 1 supportive, and it is still supportive of the revised clauses, which have changed from what clause 1 originally was. So I intend to do that next week if members are agreeable. So I'm not looking for parties' definitive views at this stage. But any questions members have, now will be the time to take them. So Simon, if you want to initially just talk to us about clause 1.
Okay. Probably in the papers you've got Appendix 1 to our Dallow letter sets out the clause by clause, and it might be useful just to have that in hand. Clause 1 of the original bill would be opposed now by Lord Morrow and the Minister on the grounds that new clauses 1A to D replace it. And it might be useful then just to go on to say what 1A and 1A to 1D do. In effect, what they seek to do is to bring together human trafficking and slavery-related offences on the face of a single piece of legislation in a form of consolidation. Consistent with previously agreed amendments that have come to the committee, the new offences clarify that a victim's consent to any act that forms part of an offence of human trafficking or of slavery, servitude and forced or compulsory labour is irrelevant. New clause 1A concerns slavery, servitude and forced or compulsory labour. It's significant in that it's triable on indictment only, which would bring it into line with the changes the committee's previously approved for human trafficking. And it's also worth noting that the maximum sentence would be increased from 14 years to life. New clause 1B is a mirror image of 1A, but deals with human trafficking as opposed to slavery, and would cover any type of exploitation. This was one of the issues raised with us, and we've sought to define what exploitation is. Also, by bringing trafficking into one offence, we're trying to address a concern that's been raised with us, that greater priority is often given to human trafficking involving sexual exploitation rather than other forms of trafficking. So the other thing to highlight is the new offence would cover all elements of human trafficking. That's arranging or facilitating, for example, travel, recruiting, transporting, transferring, harbouring, receiving or transferring control for the purpose of exploitation. And again, the sentence we're proposing would be life, not 14 years as at present. And it would also be triable on indictment. 1C, new clause 1C, defines exploitation for the purposes of the new trafficking offence in 1B. And as I mentioned, it consolidates the range of exploitation types. It also incorporates additional elements that have previously been agreed, for example, clarifying that forced begging and forced criminality fall within the range of relevant exploitation. And then finally, new clause 1D deals with preparatory offences. So that would apply where a person commits an offence, such as aiding and abetting, with the intent of committing an anti-slavery or trafficking offence. An offence under this clause, that is clause 1D, would attract a maximum sentence of 10 years in indictment and 6 months or a fine on summary conviction. There are some exceptions to that where the offence was kidnapping or false imprisonment was involved, where it would be a life sentence. Those then cover 1A to D. It's probably the first set to cover.
Yeah. I suppose we all know that in opposing doesn't mean that it's actually opposing the original intent. It's just a technical procedure.
technical.
This is a better way of doing what was originally intended, and where the department and Lord Morrow have found agreement on. So
Absolutely.
it's, no, in one sense, they're going to oppose it. It's just opposing
It's a
it.
device to
Yeah.
take it out so we can replace it, yes.
Okay. Any members, any particular questions on clause 1? Okay. Clause 2.
Clause 2, again, for the reason you state, Chair, would be opposed because it dealt with consent, and as I've just described, that's already covered or will be covered in the new clauses 1A and 1B. So there's probably not much on clause 2 unless you want me to stop. Clause 3 deals with the aggravating factors, Julie.
Sorry, we've missed out one.
Oh, sorry, 2A, I beg your pardon, clause 2A.
If you like, I'll speak to clause 2A. It relates to sentencing and would bring the new offences under new clause 1A and new clause 1B under the ambit of the public protection sentencing framework in the 2008 Criminal Justice Order. So that where the court considered it was necessary to protect the public, it could impose a life sentence or an indeterminate custodial sentence or an extended custodial sentence. And then individuals who were subject to these sentences would also be subject to the relevant release, licence and recall arrangements. So to do this, it would amend the 2008 order to specify the new offences. Both new offences would be specified under Schedule 1 as serious offences. And then it would also amend Schedule 2 of that order so that human trafficking and slavery-like offences would both be specified as violent offences, and appropriate human trafficking offences with an element of sexual exploitation would also be specified as sexual offences under that schedule.
Okay. Any questions, members, on that? No?
Chair,
Mr. Elliott?
on both clause 1 and 2, there was an indication maybe at an early stage from the department that was duplication with other pieces of legislation. Has that now been resolved?
The purpose of 1A through to D is to bring all of these offences into one
Together?
place to consolidate
Okay.
it, yes.
Yeah. Okay, that's fine, Chair.
Okay. Clause.
Clause 3 relates to aggravating factors. We had already shared a number of amendments to Clause 3 with the committee, which had been agreed with Lord Morrow, and we're not proposing any substantive changes to these, although there's a few technical amendments where, for example, there was a term used in Clause 3 that was interpreted in Clause 3, and now it appears at several points throughout the bill, and so those interpretation provisions are now included in the general interpretation clause at new clause 17A. So the effect is still the same; it hasn't changed.
Okay. Members content. Clause 4.
Clause 4 of the bill provides for a 2-year custodial minimum sentence for human trafficking and slavery offences. The Minister has opposed this particular clause throughout, although he has welcomed the fact that Lord Morrow's drafted an amendment to ensure that it would not apply to children, and he will continue to oppose the extension of the clause to adults. I mean, his view is that it fetters judicial discretion in what can be complex and difficult cases, and the Minister believes that the judiciary are better placed to weigh up all the evidence and decide on the most appropriate sentence on a case-by-case basis. But there's no amendments from us as such on Clause 4.
Okay.
Clause 5 is another clause that the Minister and Lord Morrow would now seek to oppose, mainly because Clause 5 currently amends the Section 4 of the Asylum and Immigration Act, which creates the offence of human trafficking for exploitation, and that offence under Section 4 would now be repealed and would be replaced by the new Clause 1B, so that's the rationale for opposing it. Do you want me to go on to
5A.
5A?
Yeah.
5A deals with confiscation of assets. It would amend the 2002 Proceeds of Crime Act to specify the new offences under new clause 1A and new clause 1B as criminal lifestyle offences. So the Proceeds of Crime Act sets out a chronology for making confiscation orders, and the question of whether a person has criminal lifestyle is central to the process. If someone is convicted of a lifestyle offence, which is specified under POCA, then the courts can find that they've obtained the benefit of general criminal conduct, and then that allows the court to undertake an inquiry beyond the normal 6-year limitation period for prior criminal activities. So essentially, by specifying the offences as lifestyle offences, we improve the court's ability to confiscate criminal assets related to this type of offence, and undermine the economic motivation for perpetrators.
5B.
5B exists in effect already in respect of human trafficking, and what we're seeking to do through clause 5B is to bring a consolidated provision covering both human trafficking and forced or compulsory labour and slavery. And in brief, it would enable the courts to order the forfeiture of land vehicles. That's land vehicles, one thing, ships or aircraft that were used or intended for use in connection with human trafficking or slavery-like offences.
Okay.
Chair, can I just go back quickly to 5A, sorry.
Yeah.
Is that a totally new aspect in the bill, 5A? That wasn't dealt with before in any?
It wasn't included in the original bill.
Okay.
It does. It's informed by a provision in the Modern Slavery Bill,
Okay.
so it's kind of mirroring the approach that's been taken there as well.
That's right, Chair, thanks.
Does the LCM around the Anti-Slavery Commissioner come into play here around the 5B to do with those operating at sea?
The LCM covers the Anti-Slavery Commissioner, and then there's a separate bit we're looking to cover maritime powers. Do you want me to deal with that now?
Is that connected to that?
It's not really connected, no. This is an existing power which we're extending. There's an indirect connection.
Yeah.
The maritime powers at the minute, quite a complicated area in that the police can operate within ports and seas and detain. They can't operate as effectively in our Northern Ireland territorial waters, and they can't operate at all in international waters. And what we're seeking to do there is to give greater flexibility, that if there's boat-bound trafficking victims, that the police could actually stop the vessel, detain, arrest, etc. And likewise, what the LCM would do would be reciprocal between different jurisdictions, so that if someone's coming across from England, for example, or Scotland, and they're being pursued by UK border agency, they could continue to pursue them into our waters if this is what the Assembly consents to. And as I mentioned earlier, we've consulted the board, the police and the police ombudsman about that, A, to check their content for the police, but also secondly, the arrangements for example, hot pursuit inbound. It's quite a complicated area which we'll unpack through the legislative consent motion. Julie?
I think one key distinction is the power under this clause is about forfeiting vehicles or vessels, or detaining with a view to forfeiting them, whereas the power that we're talking about in the proposed LCM is about it's about enforcement and catching people and sort of intercepting them while they're in the process of committing the offence.
Okay. So 5B is all about, once you've got them, what do you do with what you've got?
Yeah.
I've a few more questions on the LCM, but I can do that later.
I'll leave it to him.
Okay. Any members, any more questions around those clauses in 5C?
I'll speak to that. New clause 5C would introduce Schedule 2, which makes provision for slavery and trafficking reparation orders. So they would allow courts in Northern Ireland to be able to require perpetrators of these offences, of an offence under Clause 1A, 1B, or the preparatory offence under Clause 1D, to pay reparation to their victims. The model that we've used is broadly equivalent to the one that already exists in respect of compensation orders under the 1994 Criminal Justice Northern Ireland Order. Courts would be required to consider making one of these reparation orders, and so we believe that this may help to enhance the awareness that there is this means of redress for victims. And then paragraphs 2 and 3 of the schedule set out the effect of the order and enforcement arrangements for breach, and then make provision for appeals and variations.
No.
That's fine. 5D.
New clause 5D, these would bring in new civil prevention orders which are intended to help protect the public or specific individuals from the harm caused by offenders involved in slavery and trafficking. And these orders can be imposed by courts either when sentencing an individual for one of those offences or following an application by the police against what's called a relevant offender who's committed an offence in one of those areas. The detailed provisions, including the effect, are set out in a schedule which provides for variation, renewal, discharge, etc., as well as appeals. Breach of one of these orders would be a criminal offence and would attract a sentence of up to 5 years, an indictment of 6 months, and or a fine on summary conviction. These orders dovetail in with what is happening in England, Wales and Scotland as well, so we'll be seeking to ensure that orders here are enforceable across other jurisdictions and vice versa.
Okay. 5E.
Okay. 5E is a new clause which is intended to replace the existing clause 15 of the bill. It incorporates the earlier amendments to clause 15 that had been shared with the committee. So there aren't any substantive changes to what was in clause 15, and really the reason for rebadging it as new clause 5E is about restructuring so that it sits more logically with the preceding group of clauses. And it would place a statutory duty on the department to produce an annual strategy after consultation with other relevant organisations.
5F.
5F was one of the areas that we consulted on. It's a new provision again, and it's aimed at improving understanding of the scale and nature of trafficking and slavery, and therefore tailoring our response to the offences. It would place a statutory duty on specified public authorities here, so including, for example, the police or trusts, health trusts, to notify the UK Human Trafficking Centre of any cases where there is reason to believe that an individual may be a victim of slavery or trafficking offences. Obviously, where there is a potential victim, that's referred at the minute, but this is to fill a gap where there's suspected victims and there's no record kept. From the consultation we carried out, it was clear to us that this information would help government and law enforcement to target resources more effectively, to support victims better, and also help law enforcement to identify and recover victims and to target and disrupt perpetrators.
Okay. 5G.
5G, again, this is a new clause, but it effectively replicates what the effect of clause 7 of the bill, and it takes into account earlier amendments to clause 7 that we had shared with the committee. There's one additional revision that we've included. So the existing clause 7(3) provides that criminal proceedings may continue even if a victim has withdrawn their statement, and we've proposed a revision to that to clarify that criminal proceedings may be commenced or continue even where a victim has withdrawn their statement. So it's just to add a bit of additional cover. And again, we've done it as a new clause in order to facilitate restructuring, so it sits with that first group.
Okay. Clause 6.
Clause 6, Amanda.
Clause 6. I think the committee is aware that the Minister remains opposed to the provisions in Clause 6 of the bill, and that the Department has commissioned research from Queen's University in order to gather evidence on prostitution in Northern Ireland. And then if Clause 6 does not stand part of the bill, the Department would table Clause 6A, which would allow for the statutory bar on prosecutions after 6 months to be removed from the offence of paying for sexual services for prostitutes subjected to force. Proceedings could then be taken for any offence of that nature up to a period of 3 years from the commission of the offence.
Okay. Ms. McCauley?
Can I ask about the research? What stage is it at and what's the timeline, please?
Yes, of course, the timeline is that the report of the research will be presented to the Department before the 31st of October, and that a draft of that report will be with the Department by the end of September. We will then have 2 weeks to consider whether the report is within the contractual requirements. Then the researchers will have 2 weeks to finalise the report and get it back to us. And we would intend to, as far as I know, publish that report very shortly after it's received by the Department.
Okay, and one other question, thanks for that. You said that if Clause 6 were to fall, that the Minister would introduce Clause 6A. Why would you just not introduce Clause 6A anyway? In any case?
Because the reasons for Clause 6A are mainly because prosecutions where there is an element of trafficking involved, it often takes that prosecution and those proceedings to have been completed before you can then go after the actual people who have bought sex from trafficked women. So the timeline is much longer and it's much more difficult to pursue prosecutions, whereas Clause 6 is the criminalisation of paying for sex with a prostitute or with a person, actually. So there would be no requirement to extend the time when offences could be pursued.
Okay.
Mr. Wells?
This is important. I mean, this is clearly an attempt to head Clause 6 off at the pass, which can assure you is doomed to failure. Could I just say, but why, if Clause 6 is instigated, why is Clause 6 and your proposal, why are they mutually exclusive? Why can you not have Clause 6 and your proposal running in tandem? It's a slightly different question to Ms. McCauley's.
Why you can't have...
Why can't we not have both? Why can't we have Clause 6 and your...
6A?
Yeah. I can't see how they're mutually exclusive.
Simply because there would not be the justification to remove the statute bar from the offence of paying for sex to the person, because you wouldn't have had to have gone through any proceedings to ensure that the person with whom the person bought sex was a trafficked victim.
Yes, but there's two offences here. There's the offence, which hopefully will stay in, that Clause 6 makes it illegal to purchase sexual services. And there's also the purchase of sexual services to someone you knew to be trafficked, which I see as even more serious.
No.
Once you've had sex with someone.
Yes, but if that person is trafficked, then it's an even more serious offence, in my opinion.
But the existing clause does not. There is no need for the person to have been aware or not aware that the person is trafficked. So clause 6 would actually would repeal it, would take over from the clause 64.
But do you not see it's more serious? It's one thing buying services of a woman or a man who has given their consent, in inverted commas, to more serious offence, to buy the sexual service of someone who has been trafficked.
Yeah, and for the offence where it is proved that the person knew that someone was under duress, then there's a vast number of sexual offences in the Sexual Offences Order which would apply, including the offence of rape and sexual assault.
Clause 7 would again fall from the bill because it's dealt with under the Clause 5G, which Julie's covered about investigation and prosecution of offences.
Yes.
Clause 8 deals with non-prosecution of victims of human trafficking, and I mentioned in my opening remarks, Lord Moore and the Minister have agreed that Clause 8 should fall from the bill, but we'll deal later with Clause 12A, which is designed to replace it, but it is one area where we're still working with Lord Morrow and his team, and indeed others, to try and resolve it. My perception of that is we're nearly there, but there's still a little bit of work to do, and we can come back to that when we get to 12A, perhaps.
Okay, yeah. We'll look at that at 12A.
John?
Unless you want to do it now, I'm happy to take it now. It seems it's late.
Okay.
I'll speak to 12A. What we're proposing is to introduce a statutory defence for victims of slavery and trafficking who have been compelled to commit certain offences. And the clause that we're proposing would clarify that compulsion can be as a result of another person compelling you to do something, but it can also be as a result of your circumstances. We're proposing a number of more serious offences to which the defence wouldn't apply. However, even where in the case of these more serious offences to which this defence wouldn't apply, it would still be open to prosecutors to exercise their discretion in not prosecuting cases where they considered that that prosecution wasn't in the public interest. By bringing forward the defence, we think that it would provide greater protection for victims whose exploitation involves forced criminality in cases where the nature of the offence means that prosecution wouldn't be in the public interest. And we believe it may also provide greater reassurance to victims to encourage them to come forward and seek help and give evidence against their traffickers without fear of being prosecuted in the case of certain offences. Simon mentioned that we're still looking at some of the detail. Specifically, we're looking at how the defence should apply where the victim is a child, so we're looking at various options there. And first of all, to see should there be is there a need for a different threshold where the victim is a child, but also what should that threshold be? And what we want to avoid would be any unwanted consequences. So, for example, where someone has voluntarily come to engage in criminal activity but is subsequently trafficked, we want to make sure that the defence will be relevant in all cases. So we're just trying to put a bit of extra consideration in to make sure that we've got the right model.
Yeah. Questions, members?
I'm just wondering, the effect of this is twofold. One, the PPS retains its discretion, right? So that's the safety net, as it were, for all of this, because it might be contrary to the public interest if all the other things are exhausted. Might still be contrary to the public interest if a prosecution were to take place.
That's right.
So that's the safety net. This legislative change, which reflects the anti-slavery bill in Britain, it really restricts the scope of prosecution. Am I right in that?
That is correct.
Yeah.
It's to deal with the concern that a number of people who commit offences are forced to do it by the circumstances that have been
Yes.
put in through trafficking.
Yes.
And one option was to leave it all to the discretion of the prosecution.
Yes.
But the overwhelming support was for a provision where they were compelled to commit more minor offences, that would be an automatic defence.
Yes.
The bit that we haven't quite solved yet is, should there be an extra saving for, or an extra hurdle for the prosecution in respect of children?
Yes.
And in principle, the Minister's not opposed to providing special measures around children, but
Yes.
we don't want to come up with a measure that actually has unintended, as Julie says, consequences
Yeah.
for either us or the prosecution.
Yeah. But for serious offences,
The
Or,
compulsion wouldn't apply.
Yeah.
This was another concern, was that if someone committed, let's say, murder,
yes.
to try and escape from
Yeah.
a trafficker,
Yeah.
then that shouldn't be a bar to a prosecution,
Yes.
because they would argue they were compelled to commit that offence to escape.
Yeah.
So theoretically, the defence might trigger in, and we're saying no, not in the more serious cases. But you're right, the safety net could still come in,
Yeah.
even in that case, though it seems unlikely, but it would be an option for the PPS not to prosecute in any case.
Yeah, yeah. But in any event, a blanket immunity, as it were, for the victims of trafficking, that is not part and parcel of this statute.
There's immunity where they're compelled unless it's a serious offence.
Yeah, yeah.
It's not
It's a limited,
blanket,
it's a limited
as
immunity,
yes, that's the way to put
yeah,
it.
yeah, for non-serious offences.
Correct. Yeah.
Okay, thanks.
Clause 9 then, Lord Morrow and the Minister again feel this should fall from the bill. It's largely around definitions, and the relevant portions of it fall into the new clause 9A.
Yeah, clause 9 has effectively been replaced by new clause 9A and new clause 10A taken together. Some of what clause 9 was trying to do was define those persons that clauses 10, 11 and 12 would apply to. So what we've done is we've provided a general interpretation provision at new clause 9A, which in particular would define what a conclusive determination is under the NRM and who a competent authority is. And then that then allows us in new clause 10A to say, you know, who is eligible for the support and assistance under new clause 10A. So what we're proposing, if I look at clauses 9A, 10 and 10A together, what we're proposing is 9A sets the relevant definitions. 10A would effectively replace clause 10, and it sets out the requirements on the Department of Justice in respect of providing assistance and support to adult potential victims of human trafficking who have been referred into the NRM. Anyone who's any potential victims who are children would fall under the responsibilities of the Department of Health, Social Services and Public Safety. The support under clause 10A would be available from the point that a referral is made or is about to be made, and we wanted to include that about to be made as a safety net for, say, for example, if there was a police operation which happened at night and a referral couldn't be made until the next day, that there would be statutory cover in place to allow us to start that support from the point that a victim is first encountered. Our responsibilities under the EU directive are that the assistance and support should be in place from the point that a reasonable grounds decision is made, but we're backdating that to the first encounter with the victim. In terms of how the support then is to continue, it would remain in place until it's established that there were no reasonable grounds to believe that that person was a victim, or that there had been a conclusive determination either way that the individual was a victim. In the case of a negative determination, the requirement to provide support would stop. In the case of a positive determination where that person has been determined to be a victim, DOJ would be required to keep that support in place throughout the 45-day recovery and reflection period. So that period starts at the point that a reasonable grounds decision is made, and we would continue to provide support then until the end of that. And beyond that, individuals who have been determined to be victims would fall under the responsibilities of DHS SPS again, subject to their leave to remain in the country. So the rest of the clause is looking at how that support is to be provided and what that support is. And we've also taken some discretionary powers that we wanted to have in place to cover situations where, for example, an individual had to be moved to another jurisdiction because of police advice, for example, that they were at risk. So we want to still be able to maintain that provision of support in those situations, and also a discretionary power to allow the support to continue beyond the point at which it would otherwise stop in cases, for example, where new arrangements need to be in place under once a determination has been made, just to allow for transitional periods. So we're trying to provide end-to-end support for that time that they're sitting underneath our responsibilities.
Okay, next.
Clause 11 hasn't changed from the last time that we were up. It's about compensation for victims of trafficking. Nothing to mention on it. Clause 12 concerns child trafficking guardian and is an area that Lord Morrow is still engaging with DHS SPS on. It's not a matter for this department. 12A we've dealt with.
Yeah.
Clause 13 relates to the protection of victims in criminal investigations, and it's intended to avoid secondary victimisation of victims of these offences. We had previously shared draft amendments with the committee, and there aren't any substantive changes since then.
Okay.
Clause 14. Clause 14, as it stands, would fall to be replaced by Clause 14A. In effect, Clause 14 required a sizable number of changes because of other amendments we'd made, and Council's advice was to create a new Clause 14A, which in effect provides for special measures for victims in court. In a sense, it's the same as Clause 14, but repackaged because of the changes elsewhere.
Okay, members.
Clause 15. Clause 15 we've really dealt with under the new Clause 5E, which is about the department producing a strategy.
Okay. 16.
Clause 16 relates to the Northern Ireland Rapporteur. As Simon has mentioned, we've written to the committee signalling the Minister's intention to bring forward an LCM in respect of a UK-wide Commissioner under the Modern Slavery Bill. In terms of the anticipated timescale for that, we intend to seek executive approval in principle later this month, with a view to laying a legislative consent memorandum next month, and our intention would be for the LCM to be debated in the Assembly before further consideration stage. So subject to Assembly consent, the Minister and Lord Morrow would at that time seek to oppose the inclusion of Clause 16 in the bill.
Okay. So you're hoping the SAM comes it'll be after consideration stage, but before further consideration stage is the plan?
That's what we're working towards.
And in terms of the powers that are going to come over, they've appointed an interim commissioner, I understand, the Home Office.
There's a process ongoing at the minute.
And what has been DOJ's involvement in that appointment?
We were involved in the SIFT, which was yesterday, and we're on the interview panel, which is next week. And the recommendations, obviously, then we'd expect not just to go to the Home Secretary, but also the Minister and the Scottish equivalent Minister.
And where has the focus been in that appointment to ensure that Northern Ireland was going to be included?
The job description and the recruitment for the designate anti-slavery commissioner has been drafted to reflect the current provisions in the Modern Slavery Bill, on the understanding that it would then be revised subject to agreement on Northern Ireland and Scotland's position in respect of the Commissioner. So whilst the current job description and functions relate purely to the role under the Modern Slavery Bill, they will be revised and will be involved with that.
But were you involved in the appointment of the interim slavery commissioner?
That's the current process.
But what I'm trying to get is, at what point were you involved in the process? Because I understand it's been somewhat secondary, and the Home Office haven't really involved the Department of Justice in the work that they've been doing. And I raise that point because of concern that if this is how they've treated your department till this point, well then how serious can we believe that Northern Ireland's going to be important to them?
We would accept that the consultation on the process on this appointment wasn't as fulsome as it should have been. From a Home Office perspective, that was because we hadn't all signed up to having a UK-wide commissioner, because we hadn't agreed the terms of that, which there's been extensive engagement on that. However, when they told us that their plan, the Home Secretary's plan, was to bring in an interim commissioner, we then involved ourselves, and they agreed to that, and we have been involved. So I'm not going to sit here and say we're delighted with the way the process has gone. We're not. But A, they have involved us, and frankly, being on the SIFT and on the interview panel is an important part of that. And B, we do have correspondence now from the Home Secretary to the Minister, which is why we've been able to respond to, or write to the committee about the actual provisions themselves.
Because I certainly see the merits in having a UK-wide commissioner and being more effective. But if up until this point the Home Office haven't been treating us the way I think they should have been, then obviously that raises question marks, which I think need to be properly addressed, so that we can have confidence that actually, if we go down this route, it will be effective. Which one of the other questions that I have is why the Minister needs to consult with the Home Secretary before he can request an ad hoc report on Northern Ireland matters. So if you go down this route, he can't just ask for an ad hoc report. He's tied into having to consult.
The reason for that is that the Minister is involved in setting the strategic direction for the Commissioner, so as a triumvirate of jurisdictions, if you like. And clearly, if there's several ad hoc requests coming in, a person as Commissioner could be derailed from their primary focus, and therefore, obviously, consultation across, in effect, the three jurisdictions seems to us not unreasonable. We would underpin that with a memorandum of understanding. So, for example, we have said if we're asking for a specific report, naturally, we would expect to have to pick up the bill for any particular work, that research, for example, that has to be done around that, and the memorandum of understanding would cover that as well. So, I don't think we're regarding that as an unachievable hurdle. it's designed to stop a situation where so many requests come in for ad hoc reports that the Commissioner actually can't fulfil his strategic function, which all three have agreed at the outset.
And how much confidence is there that Northern Ireland will get the proper focus that it will need under a UK-wide system?
I think we're confident because we'll engage with the Commissioner, and Human Trafficking is international. I mean, the Commissioner must consider us and our border and routes in and out. It's going to be up to us to develop that working relationship as well when the interim Commissioner is in place. But certainly, from the Minister's perspective, I think he feels that the proposals that the Home Secretary has put back satisfy the test he was setting. Now, obviously, the Justice Committee may have a different view of that, but certainly from his engagement, and he has discussed this with the Home Secretary, he felt that the arrangement was satisfactory.
But that was one of the reasons why he was insisting on the power to request ad hoc reports. That was an important safeguard in ensuring that Northern Ireland would get the appropriate attention.
And what's the financial difference going to be between the Northern Ireland Rapporteur and the UK-wide Commissioner? And obviously it just doesn't come down to finance. Obviously what's the most effective system is, I think, what will be most important, certainly to me, as opposed to finance. But obviously we're living in difficult times.
Our assessment is that the Commissioner would probably be somewhere around £20,000 cost to us, depending on if we ask for ad hoc reports, so 20 to 30 perhaps, whereas a local rapporteur, if full-time, I mean this post is 95,000 I think for the Anti-Slavery Commissioner. We weren't convinced that we need a full-time post, but upwards of 50,000 if you think you need an individual with support and an office, etc. So there would be some differential in there. It was significant from our perspective.
And I suppose critically, what's more effective in terms of the actual issue? Is it going to be the 20,000 UK-wide Commissioner or a more expensive local rapporteur? What will be the most?
Our sense of this is that because many of the bodies are UK-wide and because this is an international issue, not bespoke to Northern Ireland, that the reach of a Commissioner covering the whole jurisdiction is greater. Certainly 30 of the 34 consultees favoured a UK-wide Commissioner over a local rapporteur when we consulted on this through the process. We think the reach that you get, and also actually the fact that someone who's full-time would be beneficial to us. I think the Minister said at the outset that if he wasn't satisfied with where we went on an anti-slavery Commissioner, then he would rather have a local Commissioner than no Commissioner. But again, his position is that there are distinct advantages in the broader reach, the focus, being able to call to account UK-wide bodies in a way that a local rapporteur couldn't under our legislation, etc.
Okay, and we'll bring all the members in now, but you had touched about the issue to do with those involved in human trafficking at sea and the maritime issues that will be part of. Will it be part of the same LCM? But I know other members probably want to ask about the rapporteur issue as well. So maybe if members have any other members any questions about the UK Commissioner as opposed to the rapporteur, Mr. McCartney.
It's as much, and you've given some commentary to it. See, if the LCM doesn't, I mean, this is assumed that there will be an LCM and it will go through. What's the alternative if it doesn't go through? There's no proposition in front of us. What will replace it, and how will the gap be filled?
If we didn't succeed with an anti-slavery Commissioner, the Minister's fallback would be to try and keep the National Rapporteur. I mean, we've said in early stages in engagement with the committee that we think that provision needs to be amended, but we haven't done that because we feel we're aiming at securing the anti-slavery Commissioner. But his fallback would be to have a Commissioner, certainly.
If it goes to further consideration stage and it doesn't go through, then how do we fill the gap then?
I don't think we'll have to come back to the Assembly in due course through the next bill I mean, it's got to be done through legislation, so we're going to be looking at another legislative
But
opportunity.
in relation to Clause 6 and you know, the provision for Clause 6A, is there not a need for a separate provision? There's a massive assumption that the LCM's gone through.
We're not taking the Assembly for granted, but the Minister's strong preference is to try and get an anti-slavery commissioner in place. Meanwhile, in the background is Lord Morrow's Clause 16, and it would be that we'd try and make some amendments to that if the LCM didn't go through.
No, I accept that you're not taking the Assembly for granted, but in relation to Clause 6, you're laying provision if a clause falls, that there's a fallback position to cover a gap. I don't see any provision here for a gap if the LCM doesn't succeed.
On the rapporteur?
Yeah, on Clause 16. Clause 16 is based, in my opinion, that the LCM will go through, which is fine, that's a fair assumption. But the alternative is it doesn't go through, and I think there should be something on paper for people to say, here's what happens if there's a gap.
Clause 16 is a local provision,
Yeah.
so it would be the fallback.
Yeah, that's
Although
it.
we can look at what amendments would be needed to
Yes.
that. And, yeah.
We haven't done that yet, but we can certainly do so.
Thank you.
Do you want to touch on the maritime issue?
We can do, yes. For such a small issue in some ways, because this should almost never arise as a problem, one hopes, it is extremely complicated for us to get our heads around, so I apologise if this isn't as clear as it should be. The police at the minute wouldn't have powers to seize and detain a vessel in Northern Ireland waters. They have other powers they could use, but they wouldn't have those powers in connection with the human trafficking offence. We could legislate for those locally, but we're also looking at broader powers where if, for example, PSNI and their vessel go to the 12-mile limit, pursuing a vessel with slavery victims or human trafficking victims on it, and they wish to pursue them, we would need to get a legislative consent motion to enable us to do that, because that's not it's not devolved for us to do that. Likewise, if a police service, from the Scottish Police Service or an English police service were pursuing towards us, they could not bring a power into our territorial waters. So rather than us pick up this 12-mile limit, seize and detain, the proposal is that we'd actually fix this problem so that everybody would have the power to seize and detain human trafficking and slavery victims who they come across on the high seas, no matter which jurisdiction you're coming from. Our concern about that was we could therefore have inbound law enforcement agencies coming into our jurisdiction who may do something for which we wish to hold them to account, and we've made it clear therefore, a bit like mutual aid with police officers coming here, that there should be some accountability mechanism to the police ombudsman, and that's been agreed. That is a very light way of describing this, and I'm sorry, but it's a complicated area. Julia, is there anything I've not touched on there?
There are a range of powers that are anticipated, but it's intended to sit as a package of powers that are specifically aimed at tackling these offences when they occur at sea. And it's been prompted by a specific case that I know of, it may be other cases as well, where there was a vessel which was anchored outside the 12-mile area off the coast of Scotland, and the police there weren't able to stop and detain that vessel or board it until it came within the 12-mile territorial boundary. So that's what it's intended to, or what has prompted it. Simon mentioned there's one of the specific powers intended for PSNI, which would be within the legislative competence of the Assembly. Currently, PSNI have powers to stop and detain vessels in inland waters, so within ports, but once they go into the wider 12-mile limit, so still within Northern Ireland territorial waters, but outside the ports, they don't have the express powers. They can use these other powers, for example, to secure a crime scene, to detain a vessel, but we want to clarify just and give that express power. Then there would be a range of other powers, so which would be primarily pursuit powers. So where, for example, PSNI is in pursuit of a vessel which is in connection with a slavery or a trafficking offence, and it goes outside Northern Ireland territorial waters, either into international waters or into the waters of another UK jurisdiction, that because they're currently in pursuit, their powers to stop and detain would continue with them even as they're crossing outside that 12-mile boundary. What the Home Secretary is proposing is that there should be equivalent powers for GB enforcement officers where they're in pursuit of a vessel and it crosses into Northern Ireland waters, that their powers continue with them until that vessel is apprehended, or where GB forces are going into international waters, the same powers would apply. And then the final proposal is the Home Secretary is proposing that UK Border Force, which is already effectively policing the seas in respect of immigration offences, that they, because they're there and they're looking for these type of offences, they are best placed really to identify and apprehend vessels that are suspected of being connected with trafficking and slavery. And so she's proposing a power for UK Border Force which would not be limited to pursuit situations, but which would be just as they're going about their immigration duties, if they come across this type of offence, that they would have the stop and detain powers. And on that, on all of them, we've consulted with the Chief Constable and with the Policing Board and with OPONI as well. And but particularly on that UK Border Force power, we would want to maintain PSNI primacy. So it would need to be supported with an MOU, which we haven't worked out the detail of that, but that would be the intention. So it is a package of powers which would be limited only to this type of offence, and for the most part which would apply in pursuit situations only, either inward or outward from Northern Ireland territorial waters.
Okay, interesting.
Clear as mud.
Could I just say there is a serious issue here, because some of the trafficking is of young Filipinos and other foreign nationals on trawlers. So this issue, actually, I've come across it in Kilkeel on several occasions. So this isn't just as academic as it sounds, because if the trawlerman can take the boat outside the 12-mile limit, we can't chase him. He gets away scot-free, so it will be used.
Just as a matter of interest, there's no legislation around that at the moment, is there?
No, there isn't. Not for PSNI. I mean, UK Border Force have powers around immigration already, so they are patrolling, but not for this specific type, these offences we're talking about.
Okay.
But there is a limit on what the police can do, our police.
Okay, so there are some powers, but not fully specific?
Not sufficient, yeah.
All right.
Okay. 17.
17 is effectively replaced with new clause 17A and with interpretation aspects of the bill.
Okay.
17B then, and the related schedules 4 and 5 are amendments and repeals.
Okay. 18.
Clause 18 we're proposing would be replaced by new clause 18A relating to orders and regulations. Because of the new amendments that we're proposing, they would introduce significantly more order making and regulatory powers, and new clause 18A sets out mixed provision for those powers. Basically, that a lot of the order-making powers are about future-proofing the bill in light of the fact that Scotland and England and Wales are intending to bring forward new legislation with new offences, so it's intended to pick up on those.
Okay. 19.
19 is the short title and commencement. So Simon had mentioned in his opening remarks the proposed change to the title of the bill, and that's to reflect the fact that we're repealing, really, we're proposing to repeal the existing legislation and bring it all together in one piece of legislation, and so it's no longer really appropriate to refer to further provisions, and so the proposed alternative is the Human Trafficking and Exploitation, Criminal Justice and Support for Victims Bill, and Lord Morrow and the Minister both would support that change. And Clause 19 also deals with commencement and sets out what the commencement arrangements would be.
Okay. Well, the proposed amendments don't deal with the committee's amendment about commencement.
Aye.
No.
The committee has its own amendment to remove any power the department has to choose when it would implement the bill, so that's a matter for the committee. Okay. Mr. McCarthy.
Is it just in the briefing document from the department, I think in paragraph 3, this is described as a major restructuring of the bill. Is there any part of it where you feel that the department should be carrying an EQIA on the new restructure? The proposal that Lord Morrow said, no, because the private members built a different, no sort of route through the process, EQIA wasn't required. Now with the restructuring, has the department a view on the need for an EQIA?
I believe we did one in respect of the consultation, and we've added a number of new provisions to those. We don't think they would trigger an EQIA, and certainly when we did the consultation, we had
no issues were
raised with us. Yeah.
Okay, thank you.
Okay. The major restructuring is not a departure from what were the general principles. They're pretty much still there. It's you've moved clause whatever.
Yes.
There's a whole obviously 5 A B C D E F G. So it's that restructuring as opposed to the fundamental principles behind what was originally there.
Yes.
Okay. Members, any other questions? If not, thank you very much.
Thank you.
Good work. Okay, members, next week I don't intend repeating all the discussions around minimum sentencing, clause 6 and so on, but I think by and large I'm sure the committee will still be of the same view of where we had agreement, so next week I will run through briefly where I can indicate in the Assembly committee agreement around how the bill has been restructured. If members are content, we'll do that next week. Okay, item 5 is a review of the Code of Practice on the appointment of independent members to PCSPs and District Police Community Safety Partnerships. We agreed to look at this at the 2nd of July, and officials are here from the department and the Policing Board on the results of its consultation, and then the revised Code of Practice. So relevant papers is 103 to the 170. And if Ronnie Armour with us, Deputy Director of the Community Safety Unit, Mary Lemon, Head of Partnership Development Branch, and Marie Patterson, Partnership Development Branch in the Community Safety Unit, and Amanda Stewart, Head of Partnership Branch in the Northern Ireland Police Board. So you're all very welcome to the meeting, and this will be recorded by Hansard and Ronnie. I'm going to hand over to you at this stage.
Okay, thank you, Mr. Chairman. I'm grateful for the opportunity to attend the committee today and to brief members on the outcome of the department consultation on the Code of Practice covering appointments of independent members to policing and community safety partnerships and indeed district policing and community safety partnerships. The draft code, Chairman, that's before you today is made under paragraph 6.2 of Schedule 1 and paragraph 6.2 of Schedule 2 of the Justice Act Northern Ireland 2011. Put simply, the code gives guidance to district councils and to the policing board on their respective roles in the appointments process. It's been necessary to revise the draft code in advance of the next recruitment process for independent members, which is due to commence later in the autumn. The recruitment process will lead to appointments being made in time for the reconstitution of PCSPs and DPCSPs on the 1st of April 2015, in line with the reform of local government. Preparations for that process are currently being made by the Policing Board, but it is necessary to have the code and practice in place before the exercise begins. With the agreement of the committee, Mr Chairman, the Department published a draft code for consultation in March of this year. In preparing the draft, officials took cognizance of lessons learnt following the last recruitment exercise, and in particular the advice provided by the impartial assessor appointed by the Policing Board to oversee the process. We also took advice from local councils. 29 responses were received to the consultation, and the paper we submitted to the committee in June sought to summarise those contributions that related specifically to the draft code. A number of comments were made in relation to the process as opposed to the code, and I think it's important just to make that distinction. Having reflected on the contributions we received, we have sought to clarify a number of issues in the code and have, at the request of consultees, provided an annex summarising the relevant Justice Act provisions. And in addition, we will also provide an easy-to-read leaflet summarising the code. In essence, 4 areas of concern were raised with us, and they are: firstly, how representativeness can be achieved in the context of larger council areas. Secondly, how the process can be made transparent or more transparent. For example, could elected members from one council area recruit the independent members from a neighbouring council? Should the minimum age requirement for independent members not be reduced to facilitate the inclusion of more young people? And then finally, is it appropriate to automatically disqualify a candidate if they've had a prison record and a period of 5 years has not elapsed since he or she was released either on remission or on licence? In our paper to the committee, we sought to summarise the department's thinking on these issues, but I'll briefly rehearse that again now, if you're happy with that, Chairman. On the issue of representativeness, as we indicated in an earlier paper submitted to the committee on the 10th of June, we believe there is sufficient scope within the Justice Act to allow PCSPs and DPCSPs to secure representativeness through the appointment of committees, which could be established by those PCSPs along thematic or geographical lines, or indeed for a specific purpose, for example a consultation or to arrange an event. On the issue of transparency, we believe that there are sufficient checks and balances within the process to facilitate transparency and secure public confidence. Consequently, we don't believe elected members from one area interviewing applicants from another area would necessarily improve transparency. On the question of reducing the minimum age for applicants, the Department very much recognises that young people can and do make a valuable contribution to policing and community safety. Consequently, we have strengthened the code to highlight young people as one of the groups that should be targeted by the Policing Board during its awareness-raising campaign. On the specific question of minimum age requirement, in line with the Justice Act, the Code does not set a minimum requirement. It has, however, been the practice in running the process to adopt 16 years as the minimum requirement, but that is not a requirement of the Code or the legislation. As members will know, guidance from the Electoral Office states that a person must be 18 to be eligible to stand as a candidate in local government election. And then finally, Mr Chairman, on the question of automatic disqualification, we sought advice from the Departmental Solicitor's Office and have been advised that it is reasonable to impose a proportionate disqualification period for what is an important public service role. Having considered all of the issues, the Minister has concluded that the 5-year disqualification period set out in the Justice Act should remain unchanged. Mr Chairman, I'm conscious this is a very brief introduction to the Code. My colleagues and I are happy today to take any specific questions that you may have.
Okay, thank you. Just a couple of quick questions from me, Ronnie. In terms of the process, as I understood it, independent members went to the Policing Board, no name, no score. So then it was very much all about representativeness. So how has that changed in terms of making those people aware at the Policing Board level what the score is and who the individuals are?
Amanda, do you want to?
Yes, Chair. The Code this time, and you recall the discussion the last time around the issue of merit, the Code does make provision for the Policing Board to receive scores. Whenever it was discussed as part of the consultation at the Policing Board, it was the view of the Board that its primary responsibility was to achieve a PCSP that was representative, but it would consider scores where a number of candidates would provide that representation. The scores would be made available to the appointment panels. So the Code does require the councils on this time and for the first time to provide us with an alphabetical list of candidates who are deemed suitable for appointment together with their scores. But it shouldn't affect the Board's statutory responsibility to ensure that it's representative. That's the primary responsibility for the Board.
Okay, so those board members that will be part of that process will now know the names?
They will know the scores, and they will also, the impartial assessor, whenever she undertook a review of the last round of recruitment, we had a recommendation to say that there was no need for anonymised application forms, and that was a recommendation that was accepted by the Board at that time and will be incorporated into the new process this time.
Okay, so in terms of the scores, just so I understand it, where a board needs to put on there's an underrepresentation of, say it's a young person, but there are maybe 3 young people, so they could pick one of those 3. The scores would then be provided in those circumstances?
Yes, that's right.
Okay, and same if it's female?
Yes.
The paragraph
but it doesn't happen as automatic. Here's...
It's only whenever there would be a situation of which there were a number of candidates that, as part of the decision to distinguish them, the scores would be considered. And that does happen on occasion where you get a number of candidates who are equally appointable on the basis of representation. In this case, the Code allows us to actually say to Board panel members who are making those appointments, here are the scores of those individuals that you're currently considering.
Paragraph 36(3) of the Code deals with that, just for ease of reference.
Then, is there anywhere in the Code that deals with people are appointed and then don't do their job? Because that's been a complaint in the past that people have been appointed, they don't show up to meetings, some maybe don't show up at all for over 6 months, but are incapable of then being removed.
Right, Chairman, the role of an independent member is an important one, and I think it's worth saying it shouldn't be entered into casually. Members are expected to serve in accordance with their terms and conditions of appointment, and provision is made within the Justice Act and carried through in terms of the Code for the removal from office by the Policing Board, or indeed by the Council with the Board's approval of a member if they're satisfied that he or she has failed to comply with those terms and conditions. I mean, I think Amanda might want to comment on what the practice has been, but I know it has been an issue.
Chair, in a small number of PCSPs, it has been an issue, and it is a small number of members that we're talking about. The approach taken in the Board has been to try and get those independent members to attend and to identify the reasons for them not attending. We did develop a policy on the removal of members, and in that policy we put a provision that the Board could consider the removal of members under the Justice Act, which gives us the ability to remove a member if we can demonstrate they're unfit or unable to perform their function. And by the fact that they're not attending, that gives us the provision to do that. We have made that in line with what councillors are required to do. So it states in the policy that if they haven't attended for 3 consecutive meetings without the permission of the Chair, that the Board would consider the removal of such a member. We have had a couple of instances where we have brought to members' attention that they're not attending. They have either resigned or we have gone into a process to try and remove that member or to get them back to attending again. But out of the 238 members that are appointed, we're talking about 1 or 2 individuals. We did have a case of a member who didn't actually take up the appointment and took a legal challenge against the board based on that appointment, and we couldn't remove that member while that legal case was still running, but we did seek to remove the member once that was concluded.
Mr McCartney? In your presentation, to some degree, Ronnie addressed it, but it's particularly around young people, because I mean, I talk about the experience, just locally. I mean, the success of these bodies, right? And one of the successes to me is the fact that that PSP started to do like theme meetings, and then started a theme round, and people felt it was a question and answer session all the time. I sort of welcome the fact that there's no age limit, and I don't think it should be interpreted that you have to be over 16. I think if it doesn't say 16 years of age, if a young person at 15 years and 9 months applies, then it should be accepted. Because given the life of them, you can lose people between that age of maybe 15 to 19 if they're not being selected. And I think it's an opportunity because, I mean, the police locally will tell you that, the biggest number of people they come into contact with are people of that age. So they're the people who should be helping us to shape policy for the future. So I welcome that. I think it's particularly important that, the skills, which is right, competence, but a 16-year-old has a different set of skills than perhaps a 35 or 40-year-old. Maybe allow provision for that as well. So I welcome that.
I mean, I think, as I've said, it's not a requirement in the code of the legislation. Yeah. It has been the practice in the past. But I think the Policing Board have received a detailed submission from the Children's Law Centre in the past 24 hours. I think we would want to discuss that further with the Board and obviously take account of what you've said and what members have said today.
Okay, thank you.
Mr Anderson.
Thank you, Chair, and thank you for the presentation. And the Chair asked you there about non-attendance, and you said very small numbers. You had maybe difficulties for certain members, independent members. Have you ever removed anyone for non-attendance yet?
Yes, we have.
And you have that process?
Yes. Yes.
You found the process that you've done that with was quite acceptable? And,
yes.
It wasn't a difficult process where you faced maybe some opposition to do that?
No, none whatsoever. The difficulty that we faced was actually getting to the point where we could consider that because of the legal case that was pending against us. But the process then was straightforward. We got into correspondence with, it was a couple of members, and from memory, one of those members resigned before we actually took a decision. But as soon as we started the process, they then resigned. And another member took up their appointment, but I don't have the specific details in front of me, but there have been at least 6 or 8 cases that have gone through the Policing Board during the lifetime of this PCSP, where we have, for various reasons, not just attendance, removed members from office or started that process which has led to the removal.
So you're happy there is in place that process that can be used again. Something I talked about before in the previous I just want to tease this out. Is it possible for a serving councillor to be on another PCSP? And it happened in the past, didn't it?
It did happen in the past. There was discretion within the code, although the decision by and large was at the Policing Board that they would not appoint serving councillors. There has been an amendment to the...
Has that loophole been closed?
It has been closed, yes.
Has that caused a lot of discontent in the sense it sort of skewed the political representation on the balance of these? If someone came from a political party as an independent to sit...
There's nothing to prevent someone from a political party applying to be an independent.
I understand that, but a sitting councillor...
A sitting councillor can't.
From one district cannot sit on another one. If you're a serving councillor, you're automatically barred, is that right?
There was an amendment to the Local Government Bill which closed that loophole, which prevents a serving councillor on the 11 councils, as it will be, applying for membership of any PCSP.
Yeah. It was a loophole, and I'm pleased now that has been addressed and closed.
But the issue has not been specifically raised since the loophole was closed. I think can answer your question.
Yeah. Okay. Thank you, Chair.
Mr. Lynch?
And one question, thanks, Chair. In terms of an appeal process, where persons might feel that the process denied them onto the PSCPs or PCSPs, what is the process of an appeal? Or do they have one?
In terms of they feel that they have been in some way, I mean that's an issue that they would raise in the first instance with the policing board, who in turn would look at that. But ultimately, someone might take it to, and people have taken to a tribunal as the ultimate court. So the appeal mechanism would in the first instance be to the board.
And people have taken cases?
We've received complaints as opposed to appeals, and I suppose you could look at that a complaint is an appeal. There would be no provision even if a complaint was upheld for the board then to make an appointment, because in a sense the positions have been filled. And each of the PCSPs has a restriction in terms of the number of independent members that actually apply. But there is provision within the code for an independent complaints monitor outside of the board, and we seek to establish that each time when we start the recruitment process. And ultimately then people can take a case to a tribunal as well as the ultimate appeal.
Okay, thank you.
I'm just trying to understand what representativeness, what the object of it is. Is it in a situation where you have council members, right, who say are predominantly unionist or predominantly nationalist, and you want to balance that out across independent members to have a greater representation of, say, nationalists or Catholics, or you know, the other way around? Is that what it's about, or what's the objective of it?
The objective of the representativeness is to make the PCSP as representative as the district as possible.
As the district?
Of the district. So in this case it would be the council district, and in Belfast it would relate then to the police districts.
Right.
In terms of the process for doing that, we would ask our NISRA colleagues in the board to look at the demographic profile of the council using the census figures. We would then look at the profile of the elected members who have been selected by the council to take up their positions, and we then identify where the gaps would be to make it representative of the district.
So you're filling in those gaps. That's the purpose of it. Now, just in relation to the representation of women right across Northern Ireland on these bodies, what is the percentage? Do you know?
I don't know. I would have to get that information for you.
And do you aim to get, as it were, a regional representation in that sense? That, you know, I don't know how many percentage, in percentage terms, how many women make up the population, but let's say 50%. Do you try to get 50%?
We did, from memory, Chair, we did get regional representation around women. There were a couple of PCSPs where there was still an underrepresentation. Yes. Part of the challenge that the board have is that the profile of councils has typically been male-dominated.
Yes.
And the members of PCSPs that we then, so in a sense, whenever the board goes to make the panels, there's certainly a perception out there that if you're a male, you won't be appointed. And some people have said that to us, but we do try and make it as representative as possible. In some areas there wasn't a full representation of women, but I do recall from the last time that we did meet the regional Northern Ireland representation figure.
So you've met your target in that respect. Now, just in relation to turnover, has there been much of a turnover? I know you've mentioned people that haven't attended and so forth, and you've dealt with that. But in terms of people just simply saying, well, I want to move on to do something else, has there been a turnover?
There has been a turnover. The code allows us to keep a list of reserve candidates, yes. So right up until the date of the local government election, whenever yes. We're not allowed to fill vacancies, we have filled vacancies. It has probably been consistent with the old DPP model. You would generally yes. find there were a couple of PCSPs that we completely exhausted
the reserve list. From memory, Coleraine, Moyle and Omagh.
Yeah.
We didn't have any reserve candidates and we needed to go back out and run another competition.
Right.
But there probably was marginally more people leaving the PCSP than maybe we would have had leave the DPP in the past.
Yes.
And it's just, in a sense, the 4-year term is a long time for some people, and particularly
Yes, of course.
one of the issues that we're currently working with the Youth Advisory Panel and the board is around young people and what a 4-year term means if we appoint young people onto because they move away to university.
Yes,
And the implications of that.
Might it be that you have in the next recruitment perhaps a longer reserve list?
We try and keep as much of a reserve list as possible, but in some areas we didn't get a huge amount of applicants through. So in those areas in particularly, from memory, Moyle, we maybe had 2 people on the reserve list from the appointable pool that came back from the council.
And would you say the turnover is about, what, say 10% or sort of?
Probably about that.
Around about that. Just in relation to another issue which is much more contentious, and the Chair can rule me out of order if it isn't relevant to your presentation. But in certain areas, people have been identified with paramilitary organisations, independent members, and it's become a subject for some discourse, public discourse. And yet, despite the clear identification of people, I'm not going to name names, nothing seems to be capable to be done about their representation as independent members. Has any consideration been given by the Department of Justice to this particular problem?
I mean, as members will know, Chair, I mean, upon application, individuals are required to sign a declaration against terrorism, and that under a successful interview, they then undergo a criminal record check. The Justice Act disqualifies individuals who've been convicted or imprisoned or detained during the 5 years prior to their application from holding membership following appointment, and following appointment, members can be removed if, in the case of an independent member, they fail to disclose a conviction or they have demonstrably acted in breach of their terms of their declaration against terrorism, and or if they're convicted of a criminal offence after appointment. It's not the role of the department to remove them, but I certainly take your point in terms of consideration of that issue. That would require legislative change. We're not proposing legislative change at the moment. So in that sense, the department are bringing forward proposals on that. During the consultation period, it's not an issue for the code. It's not an issue that was raised with us. Certainly if the board, and again Amanda may want to speak on this, but if the board were to move to remove someone, they would need to have clear evidence to do that, and they would need to be in a robust and a strong position to defend a legal challenge. So hopefully that answers the question in terms of the department's position.
Mm-hmm.
Chair, I don't have anything further to add. It has come up in a couple of PCSPs, as it would have come up in DPPs previously, and the issue goes back to what Ronnie has said. There needs to be clear evidence to support the board removing a member on any basis, not just on this, otherwise we leave ourselves subject to a challenge. On the specific case that I recall that came before the board on this, all we had was media speculation.
Yes.
And the police were saying to us that it wasn't sufficient grounds to consider the member's removal.
Thank you very much.
Mr. McGlone.
Yep. Thanks very much, Chair, and thank you for being with us here today. Just a thought occurred to me there, because obviously inspired by experience and maybe some of it anecdotal. Has either the department or the policing board or anybody done an audit of the PCSPs to see how effective they are? And I would reckon that it'll come back pretty piecemeal.
Well,
they've been too prejudiced about it.
We currently have a review of effectiveness ongoing that's been led by the Criminal Justice Inspectorate.
Right.
Earlier this year, we invited the Inspectorate to come earlier than planned to have a look at PCSPs and to give us a report on their effectiveness in time for the relaunch next April in the context of local government reform. We're still waiting on the final outcome of that. It's due later in the autumn, and I think we are committed to come back to the committee at that stage with a report on the outcome. So yes, our review is underway, but it's not by either of our organisations. It's by CGINI, which I think will be extremely helpful to us.
Okay, thank you.
Just finally, in terms of you get your names. It's a young person. You need to fill a space. So say it's a young male. There's 5 of them. Scores are all released. What discretion does the board have to then pick one out of that list and bypass an individual that obviously is the top score?
Well, it's not an exact science, and it is a difficult issue and difficult question. I mean, in terms of the board, as Amanda indicated earlier, in line with paragraph 363 of the code, they would be looking at a range of representativeness issues. It would come down to being difficult to distinguish between them. Then the score would be used. I mean, if you got down to the stage where they were all on the same score, I think that'd be a very difficult position for the board to be in. But I think, they would ultimately have to take their decision based on the representativeness issue.
Mm-hmm. Say there's a young male, and the scores are revealed to this panel, but one of the members of the panel knows there's an individual who, say it's in a working class community where there's antisocial behaviour problems, but didn't score particularly well, but reached the bar to get appointed. And there's a young male in an affluent area where there's no real policing problem. And that knowledge of the appointing boards brought to their attention, say, I actually think this is where the police need to be. There needs to be that community engagement, but they didn't score particularly well, and I think it should be that person. Is that a ground? Is that representative of a social class that could be justified as to why you didn't pick the top person?
I think it's very difficult, and I think the board would want to be very careful in taking that decision in the context that they're always vulnerable. They're always vulnerable to challenge. I mean, I think yes, they reflect on the representativeness issue in terms of the young person and their background. But I think where you couldn't distinguish, then I think you are down to scores at the end of the day. But I appreciate it is a difficult one that the board would have to, in the circumstances of the case. But
Chair, just in terms of the last process, the board did try to look at getting representation, particularly from young people and from socially disadvantaged communities. So in a sense, it probably would factor as part of the discussion. It wouldn't necessarily mean that they would make an appointment. It isn't a scientific process where you take a number of males, a number of females, you go to age categories. You could get to making an appointment and realise that you haven't got representation from the business community, or maybe you had 3 people from the business community, or maybe it was a rural community and you didn't have representation from Ulster Farmers Union or NERTA that put forward a number of people the last time. So it is a discussion that the board would get into as a panel. What they can't do is bring any knowledge of the candidate into the discussion. They can and around the representation, but the independent panel member and the impartial assessor would intervene if the board members were to bring any knowledge of any candidates that they knew were maybe working in the community or in that instance. That they wouldn't be allowed to bring that in because that would be seen to be additional information that was being supplied.
But what if that additional information would prevent an appointment, which would then have quite serious ramifications
into question and jeopardises the integrity of the process. And that's why there are so many checks and balances around independent panel members and the involvement of the impartial assessor in that at both council stage and at the policing board stage.
I suppose no matter what system you have, you're never going to get 100% perfection. I acknowledge that.
Sure.
Mr. Anderson, have you
just
supplementary
to come back,
include?
No, it's not. It's something I meant to ask. I forgot to ask. We're talking about non-attendance. We talk about the designated members to these PCSPs. Is there any problems with these people for non-attendance as well? Because I remember in the old DPPs and CSPs and there was difficulty with statutory bodies and all failing to turn up, and not only that, they kept sending different people at different times, which didn't give a lot of consistency with what the safety partnerships were at that time intending to achieve. So do we have a difficulty, or did we have, as Mr McLone had asked, any feedback from what is taking place now that they attend those people who was causing a problem, if not, or not?
The Policing Board wouldn't have any authority to remove a designated body. We can only remove either a political member or an independent member from a PCSP, so the attendance policy doesn't apply to designated bodies. We have asked CGI...
So I'm asking about, Amanda, was there a problem? Did we identify any issues coming through from the PCSPs in relation to maybe those people for non-attendance?
I'm not aware that any of these...
What is the minimum? Is it 4 or many can it designate? Many can
seven designated organ. I mean, I'm not aware of any specific issue and answer to your question. I mean, there may be issues across the 26 councils around attendance, but none have been specifically raised with the department.
And I suppose we would just maybe add that obviously we're aware, you're right, no specific issues have been raised in relation to non-attendance. We are aware that there's maybe some work to do around really fully utilising the potential of the designated organisations on the PCSPs, and that's certainly one of the issues we would want to be looking at in terms of going into the new arrangements next year, just trying to do some work to make sure that that potential of that full partnership is fully realised, including the designated representatives.
Is there a possibility you could get maybe some figures on those attendances to see if there was a difficulty? I'm not saying there was.
More than
I did hear on one occasion of maybe one particular organisation not quite so well. So I'm just wondering, has it been across the province, and is there a possibility that some work needs to be done there to ensure that they do attend and they take serious the position that they're taking up, just like the independent members and the political members?
I'm more than happy to seek that information from councils.
It may have been very good, but we don't know that.
Absolutely, more than happy to seek that information.
Yeah. Okay. Thank you.
Okay. Can I thank you very much for coming to the committee? It's been very helpful and I appreciate it. Okay, members, are you content then that we would note this guidance? Agreed. Item 6 then is on pages 172 to 179. At our meeting on the 30th of April, the committee considered and agreed that we were content with a proposal from the department to make a statutory rule to extend Code A modifications which facilitate the recording of search details electronically using BlackBerry devices until publication of a revised Code A. The statutory rule was laid by the department on the 30th of June. It's subject to negative resolution procedure. The statutory rule allowed continued modification of Code A to come into operation on the 30th of July. There have been no changes to the policy content since it was submitted to the committee, and the Assembly Examiner for Stat Rules has confirmed that he has no issues to raise in respect of any technical issues. So if members are content, I'll formally put that question. That the Committee for Justice considered Statutory Rule SR 2014-181, the Police and Criminal Evidence Order 2014, and has no objection to the rule. Agreed.
Right.
Item 7 is the timetable for committee stage of the Justice Bill. It commenced, as members know, on the 25th of June, and the 30 working day period provided under standing orders for completion of the committee stage is due to finish on the 30th of September. Standing order provides that before the conclusion of the 30 working days, a motion may be made in the Assembly by my or the Deputy Chair to extend the period of the committee stage. The motion must specify a date to which the committee stage will be extended. Given the size, complexity and range of policy areas covered by the bill and the volume of other business the committee is also seeking to progress over the next number of months, it's proposed to seek an extension of the committee stage until the 27th of March 2015. If members are content with that proposal, then a motion will be lodged in the Business Office, which will read that in accordance with Standing Order 33.4, the period referred to in Standing Order 33.2 be extended to 27th of March 2015 in relation to the committee stage of the Justice Bill. So if members are content, then I'll seek to have that motion debated on the 22nd or the 23rd of September. Right, content. A legislative scrutiny workshop with Daniel Greenberg to assist the committee's scrutiny of the bill has been scheduled for Wednesday the 1st of October, and that will be from 1:30 p.m. through until 3 p.m, which we had planned to do, and I've been trying to get an appropriate point to do that, so I think we've reached that stage where this is the best time to do it, so if members can take note of that. Item 8 is the Northern Ireland Prison Service Estate Strategy Progress Report on the implementation. The Minister announced on the 19th of March last year his decisions regarding the development of the estate as set out in the strategy. Officials subsequently briefed the committee on key elements of it. The Department has now provided a briefing paper setting out the current position in relation to implementation of each of the projects within the Prison Service Estates Strategy. So if members are content to note that information, it can be used for future meetings when the senior management team are before us, unless there's any particular information members which wish to seek now. Otherwise, we can refer back to it when officials are before us. Item 9, legislative provision in relation to rights of audience of lawyers working in the Attorney General's office. The Attorney has invited the Minister to consider making legislative provision to confer rights of audience equivalent to those of barristers in private practice on any barrister or solicitor working in his office and designated by him. The Department's provisional soundings with key stakeholders indicate proposals may have some implications for the wider legal service landscape and the regulation, which need to be identified and evaluated. The Minister then is thinking it appropriate to allow key stakeholders the opportunity to formally comment on the proposal. The Department is issuing a preliminary discussion paper to invite views. The responses will inform further consideration on the proposal and then, if necessary, a need for wider consultation. Those preliminary views are to be sought by the 10th of October. So if members are content to note that update.
Chair, just for clarification, that is bringing those legal people who work in the Attorney General's office into line with private practice. Is that correct?
It would give them those rights of audience if the Attorney General would designate them to do that on his behalf.
Just wondering what the issue would be if some people may object to it, or is it that have concerns with it?
If who objected to it?
If there were people, if there were any organisation would have concerns with it. Are we aware of any? That's what I'm saying.
I think this is why the Minister has decided to take this approach.
Or I should narrow it down. Has the Department any problems with it?
I'm not sure if the Department does. I think there's been initial soundings, from what my understanding is, with the wider legal profession, and some are indicating that this could have implications that they would want to be more formally consulted upon. So that may suggest there isn't a 100% green light coming from somewhere. Where exactly, I'm not sure, but
okay.
Item 10 is a review of the strategic framework for search and rescue in Northern Ireland and the proposed next steps. The Department assumed policy responsibility for land and inland water search and rescue in Northern Ireland on September 2011 to ensure the overarching search and rescue frameworks appropriately governed and structured. A strategic review was launched which looked at the organisation, administration and funding of search and rescue organisations. The Department has now provided the report of the review, which contains 13 recommendations relating to the implementation of a new strategic framework and for search and rescue in Northern Ireland, including the establishment of a Northern Ireland Search and Rescue Policy Group and a Northern Ireland Search and Rescue Practitioners Group. The Department has also provided an implementation plan, a framework, mission statement in terms of reference for the new groups. So members are asked to note the outcome of this, unless there's any further information members wish. Okay, noted. Item 11 is the draft adult safeguarding policy. The Department has provided a copy of the draft policy, which has been jointly developed with the Department of Health, Social Services and Public Safety, and which intends to publish a consultation later in the autumn, subject to the views of the committee. The aim of the policy is to improve safeguarding arrangements for adults who are at risk of harm from abuse, exploitation or neglect, and it sets out how adult safeguarding will be taken forward across all government departments, their agencies, and in partnership with community and voluntary organisations. The Commissioner for Older People for Northern Ireland, Claire Keating, has also written to the committee providing a copy of a report she published in June entitled Protecting Our Older People, a call for adult safeguarding legislation, and requesting an opportunity to brief the committee on the report, which makes specific recommendations to the Minister of Justice and Minister of Health to introduce new adult safeguarding legislation and highlighting gaps and weaknesses in the current legislation. The Department has indicated that it has held a number of meetings with the Commissioner, and her report has helped to inform the policy statement. So Claire Keating had been in correspondence with the committee prior to the Department providing us with this draft policy. So if members are content and that we would note the intended consultation, we would consider then the draft policy further when the results of that consultation are available, and at that point we would facilitate a briefing by the Commissioner to help us in our consideration of that policy. Members are happy with that approach? Agreed. And item 12. The Home Secretary recently announced her intention to introduce a new criminal offence of police corruption in England and Wales, which is intended to supplement the existing offence of misconduct in public office. Its scope is wider than that of the existing offence, and an amendment has been included in the Criminal Justice and Courts Bill, which is currently going through Westminster. The Minister of Justice here has now written to a range of key stakeholders seeking initial views on a proposal to introduce legislation to create a similar offence of police corruption for PSNI officers, and has provided a list of questions for consideration. So if members are content to note the consultation paper, and then we can consider the matter further when views have been expressed. Okay, noted. Item 13. Following a oral briefing by the Department officials on revised proposals for firearms licensing fees and other firearms issues at the meeting on the 18th of June, the committee wrote to the Minister to express its concern regarding the lack of progress on this matter, and requested information on how the Department has engaged and planned to engage with key stakeholders to reach a resolution, and a breakdown of PSNI travel expenses which form part of the cost of granting or renewing a firearms certificate. The Minister has responded, providing information on his Department's engagement with key stakeholders, how the travel expenses have been calculated, and he's outlined the Department's recent consultation with key stakeholders on revised proposals, which closed on the 29th of August. 19 responses received are currently being collated and will be shared with the committee as soon as possible. The Minister has stated that an initial assessment indicates that the non-fees aspects require further discussion, and this is to be arranged. The fees will be dealt with separately and are currently being reassessed by DFP Business and Consultancy Service. A fees workshop is planned for October, to which all of those with an interest will be invited, and departmental officials will then update the committee again in November. So members are asked to note that information unless there's any more views. Mr. McGlone.
Chair, looking through some of this stuff, I find it a wee bit bizarre, this letter. The letter dated the 4th of September. Particularly the figures around visits and the reason for 3 visits. I know of no case, unless there's a huge problem, where 3 visits are made. And likewise, any firearms officer doesn't be ping-ponging back and forward every day or every other day for a visit. What they do is they, like any efficient person does, they collate them all and do one area in the one day. So those figures are a bit bizarre, and potentially a land check. Land check is only for usually a centre-fire rifle. The bulk of them are air rifles and shotguns, which don't require land visits. So I think whenever the officials are back, we need to have a chat with them, and as well as that, it might be helpful too for those members who are around the room who have a particular interest in this to actually find out what this engagement, these engagement meetings are, because I'm getting mixed reports back about what they actually are. They may not be as meaningful in their engagement and more laying out the party line by officials and others. So I think it would be helpful for us to glean firsthand if members of this committee, or indeed the whole party group on country sports, were notified, and if they're able to attend, could attend these engagement meetings. And then finally, there's one other point, Chair, and we'll come back to this whenever we have the officials again. It has been mentioned to me that all of a sudden the EU Weapons Directive 2008-51 has popped up, and it's causing some concern in how it's been interpreted to some small dealers. So would it be possible that this committee please get some research done as to what exactly that is and what it involves, please? That's okay, Chair.
Yeah, I'm certainly happy with that.
Okay, thank you.
And you want us to write to the department indicating that members should be advised if they're able to attend any of these engagement meetings?
I think it would be very helpful, because at the moment we're getting what appears to be a largely sanitised version coming from the department here, and some of it which is questionable, as I've just outlined there. And on the other side, we're hearing what appears to be quite a different and real story coming from some of the people who have been allegedly invited to these stakeholder meetings.
Okay. I'm happy for that.
That's grand. Thanks, Chair.
Okay. There are 34 items of correspondence and in your meeting folder, and then one item in the tabled pack, and I'll draw attention to a number of them, and any that I admit members feel at liberty to raise in due course. Item 3 in the meeting folder is correspondence from the department providing a copy of the final report that it commissioned with Queen's University into legal needs of children and young people in Northern Ireland. So members are asked to note that information, which we will then be able to use at the appropriate time when we're considering proposed legal aid reform changes. Item 6. There's a response from the department to the committee's request for information on the costs of providing the rapid assessment treatment service for drug and alcohol misusers programme and the position regarding funding of the programme. The department has indicated that as it does not have an operational relationship with Addiction NI, it doesn't hold any financial information that would assist the committee in ascertaining the annual cost or any estimate of the cost of extending this programme to other court areas. So if members are content, we'll write as a committee to Addiction NI to request the relevant information. Agreed. Item 22 is correspondence from the Committee for the Office of First and Deputy First Minister inviting submissions from all statutory committees to its inquiry into building a united community. And if members are content, we'll request a response from the Department of Justice on any relevant issues covered by the inquiry to inform consideration of the matter. Item 26 is correspondence from the Clerk to the House of Lords European Union Select Committee in relation to its inquiry into the UK's opt-in policy and its application to international agreements. And if members are content, we'll seek a response from the Department of Justice on any relevant issues that are covered by the inquiry to inform consideration of the matter. Item 33 is correspondence from the British Association for Shooting and Conservation, raising issues regarding the lack of accountability of PSNI firearms and explosives branch staff, asking that the committee consider changing the legislation to give the Police Ombudsman the remit to investigate complaints against PSNI civilian staff. The correspondence also refers to a letter to the committee from Mr Trevor Clark MLA, highlighting what in his view is a serious lack of accountability within the PSNI firearms and explosives branch and a lack of objectivity and fairness. So if members are content, we will send this correspondence from both Mr Clark and BASC to the Minister for Justice, asking him to deal with the issues that are raised in both letters. Obviously, members will be aware that the Department has had a consultation on the powers and remit of the Police Ombudsman's Office, obviously with the intention of trying to make some legislative change. So this may be an area that obviously can feed into that consideration, but obviously that bill hasn't came through the executive yet, so if members are content, we will send the correspondence on to the Minister asking for a response to the issues raised in it. Item 34 is correspondence from the Disabled Police Officers Association, raising a number of issues regarding the handling of an investigation by the Charities Commission for Northern Ireland, the impact on the association's work and the services provided to disabled police officers, the role of the Department of Justice in accessing the association's premises and potential breaches of data security. This, members, is something that I became aware of during the summer. There has been a pretty substantial folder was handed to me and handed to me in my capacity as chairman of the committee, so I passed it on as necessary to the clerk of the committee, and that's available for any member obviously that would want to have a look in more detail at what is raised within it. Needless to say, I think it's pretty serious, but at this stage don't wish to go into the details, but having looked at it, I think there's a number of things that we could do to try and seek some information before we may wish to give the matter further consideration. So I'm going to propose to members that we would write to the Minister of Justice requesting a response to the issues raised regarding the impact of the actions taken by the Charity Commission on this organisation's work and the services provided to disabled police officers and the role of the Department of Justice in accessing the premises and the potential breach of data security. Also, given that responsibility for the Charity Commission for Northern Ireland sits with the Department of Social Development, that we would forward this correspondence to the Minister for DSD to consider and respond to the association on the issues raised regarding the handling of the investigation by the Charity Commission, and that we would then also write to the Committee for Social Development to enable it to consider the issues raised which are relevant to that particular committee. So if members are content that we would take that approach. I have already corresponded as an individual MLA because of constituents that contacted me, raising some of these matters with both the Minister for Justice and the Minister for Social Development, and awaiting a response in that capacity. But given that I was passed this information as chairman of the committee, I would suggest this course of action at this stage. Mr. McCartney.
I met with Elaine Hampton from the association, and obviously she had informed me that she was meeting or had met herself. But I think she asked me that they would make a request that they would come in front of the committee, which I think they should consider as well, perhaps after we get the correspondence, but she did ask for a sort of meeting.
Yeah, and I'm happy to facilitate that if that becomes necessary. So I would like to get this information initially, and then the committee can consider how we would want to take it forward thereafter.
Yep.
Okay, then finally the other item in correspondence is in the table pack, and that's from a Mr. Trevor McKee, who had requested a meeting with the committee in relation to the alleged mistreatment of the Loughney rescue by the Charity Commission. Again, from Mr. McKee has raised his concerns with the Department for Social Development, and following a number of requests, a meeting has taken place. So if members are content, we'll forward the correspondence to the Minister for Social Development to consider and respond directly to Mr. McKee on the issues raised, and that we would also write to the Committee for Social Development highlighting the issue with them, so that if they wish to consider the matters raised, they can do so. Okay. Is there any comments on correspondence that I've neglected?
Chair, there's just one issue there. I note the Policing Board Performance Committee, was it, has written regarding, it's basically support for the Attorney General having his amendment in the Legal Aid and Coroner Courts Bill. Just wondered, does that need a response to say that it is being considered under the Justice Bill that's coming up?
We've already gone back to the Policing Board when we were seeking comments on the Justice Bill and advised them that we're going to look at that particular amendment in the capacity of this bill now. So,
just because obviously the letter is dated the 3rd of July, and we I think had decided before that, you know, that we weren't going to include it, as far as we were concerned, as far as the committee were concerned, in that particular bill, but that we were going to look at it in the other bill, Justice Bill. So anyway, as long as it just...
It's sort of crossed. We then wrote to him on the 7th of July advising about the Justice Bill and seeking comments on it, and advising that the committee would again look at that amendment.
Okay.
At that time, the Policing Board have come back saying they will be putting in response on the Justice Bill, so they may well touch on that again, but we'll keep the two together.
That's okay. Thank you.
Okay. Chairman's business, there's the chairperson of Committee for Culture, Arts and Leisure has invited I and the Deputy Chair to an event to which the BBC Director General will outline his vision for the BBC, and in particular BBC Northern Ireland. And hopefully I and the Deputy Chair will be attending. Also, there's an invitation from Mid and East Antrim Age Well Partnership to a consultation event on older people and the fear of crime. The Mid and East Antrim Age Well Partnership is writing the committee inviting myself or a member of the committee to attend any of the 3 consultation events that are being held in Larne, Carrickfergus and Ballymena, to find out how the fear of crime affects older people and their knowledge of the existing support services. I suspect members in those constituencies may well have already been invited, so if I'm able to attend, I'll seek to do that. If I'm not, I'll see if there's another conscript that might want to go and represent the committee. Any other business? I have one item that I wanted to raise, and that was in respect of the RUC Widows pension issue. There seems to be ongoing problems in what the Assembly had passed. The media have picked up on it, and I think it would be appropriate that we would write to Minister Ford trying to get clarification on why payments haven't been made when they should have commenced on the 1st of July, and the same letter can go to the Minister for Finance, because I think it would appear that the two departments are associated with trying to resolve these matters. So if members are agreeable, we'll write to both ministers asking for them to advise this committee as to the current position, why it has got to this stage, and what's being done to resolve it, and when. Members are agreeable to that. And Mr. Anderson.
Yes, thank you, Chair. Chair, I've been contacted in recent days and weeks by a number of prison officers expressing great concern in what is happening and the way the regime and the operations are being run at HMP Maghaberry. I believe there is such, and the information I'm getting, it certainly is very disturbing, because what I'm hearing is there are a number of staffing issues there, is a number of health and safety issues there, and generally the whole operation, and it is causing such a problem that there's really big concerns for safety of staff and indeed for the prisoners as well in what is happening. So I would think it would be very appropriate that we get the Prison Officers Association to present to us, to update us on what is happening at Maghaberry, and possibly senior management as well at separate times, possibly and hopefully with the prison officers first of all, to hear their side, and to then to get management in as well, if that would be agreeable with you, Chair, because I don't know if other members have received this or not, but I certainly have, and it's something that I think needs to be addressed and taken up.
I know Minister Kennedy, Mr. Elliott's colleague, has mentioned this to me as well, to do with staffing pressures and resource implications within prisons. So I'm certainly happy that we would invite the POA to come in and speak to us. The senior management are due to be before us just before the Halloween recess in October. So if members are agreeable, we would seek to facilitate the Prison Officers Association to come before the committee sometime before that meeting. Are members content with that? Any other business?
Chair, just when you're talking about the RUC Widows pension issue, what about the equal pay campaign? The last correspondence we got, I thought, was slightly more positive, but it seems to have all gone quiet over the last few months.
We have received in the last couple of days in the office a number of letters from people to the committee, which will be going to the PAC next week, which again seems to be raising the same issue as previously.
Can I ask maybe, Chair, in light of that, then, if we're getting those letters, that we would get a response from the department for next week as well?
Still with the Finance Minister.
I think there is responsibility there as well, but obviously we can't, we can only deal with the Justice Minister. As far as I know, it's a joint.
I'm happy to ask the Finance Minister to respond as well.
Yeah, because I think otherwise, Chair, we would get the same response from the Justice Minister as we got the last time, which is the matters with the Finance Minister.
What was that? Remind us.
Which might just be that he's a bigger headache than just the issue of one pension issue to deal with.
Okay, any other business then? If not, we'll meet next Wednesday at 2 p.m. in the same room, and remember the strategic planning meeting will be prior to that at 12:45 in the private dining room. Thank you.
21. This is the